Hello, everyone. Again, I'm Professor Robert Romano, but I say that every week. And welcome to Module 4. This week, we are going to be talking about criminal law and ethics. All right, so this week's about criminal law and ethics, and at the end of the week, there'll be a quiz. The quiz, again, will be open for 2 days, so you have more than enough time to take it. Criminal law. What is criminal law? Right, we talked about civil law last week. But what's the difference between criminal law? I mean, think about it for a second. In your mind, when you say criminal law, what images conjure up besides Law and Order and CSI and NCIS? Criminal law is a body of law that identifies what behavior we as a society feel is criminal. And part 2 to a criminal law is that it has to stipulate the penalty when somebody violates it. Okay, so there are 2 parts. If something's called a criminal law, not so much a crime, but a criminal law, it's the body of law that identifies what behavior we as a society have agreed upon to declare criminal, and there has to be a stipulation for what penalty is going to be imposed if that person violates or proceeds with that criminal act. Okay? Criminal law, it's the state on behalf of the people that bring the cases, all right, as opposed to civil law. In civil law, you as a private individual can bring a case against somebody else. In the criminal law context, the only one that can bring the case is the state, all right? And when I say state, I mean prosecutor, district attorney, all right? They are the state. They work for the state, and they can bring a criminal act against another person. You can't, I can't. We can bring civil actions, but not criminal actions. They bring, the prosecutor's attorney, they bring an indictment or an arrest warrant against the person. Okay? And in this indictment or arrest warrant, it alleges which crimes the defendant which criminal law the defendant violated. All right? And at such time, if you qualify, if you were arrested or indicted, you have a right to an attorney. If you cannot afford an attorney, one will be given you for free of charge. They're known as the public defender. I know we've heard that 1,000 times on TV. If you cannot afford an attorney, one will be appointed for you. That person that's appointed is the public defender. So the prosecutors bring the cases against the person who's violated the law or allegedly violated the law is entitled to representation also, and they are given a public defender. Okay. They also, but if they can afford it, they have a right to private defense counsel, but they are paying for it. All right, public defender is usually free or a nominal fee at least. Private counsel, defense counsel, is usually going to charge the person, and they charge a lot of money. Okay. Crime, criminal law. Crime is an act done by an individual in violation of that criminal law or duties owed to a society. Okay. It's an act done by an individual, you, me, whomever, your sister, your mother, a guy down the street, kid across the hallway. It's an act done by an individual in violation of the law or duties owed to a society. And that's a crime, not a criminal law, that's a crime. Burden of proof. We talked about this previously on the civil action. Burden of proof, there are 3 different standards. All right? In the criminal court, it's beyond a reasonable doubt. The prosecutor who's bringing the case on behalf of the state has to prove his or her case against the alleged defendant beyond a reasonable doubt. That means there can be no doubt in the juror's mind that the defendant did this heinous act. Okay, 99.9%. As a juror, you have to be 99.9% sure that this person did it. If you have any doubt in your mind, the person must be acquitted. Okay, that's the burden of proof. That's the standard we use in criminal law. As opposed to clear and convincing evidence, which we talked about previously, is about 75% sure, or a preponderance of the evidence, which is about 51% sure. The scales shift one way. All right, preponderance of evidence is used in civil court. Clear and convincing evidence is used a lot in administrative hearings, and beyond a reasonable doubt is the standard used in criminal court. In a criminal case, the prosecutor must prove their case beyond a reasonable doubt. There are classifications of crimes. All right, there are two classifications: a misdemeanor or a felony. All right, a misdemeanor is a crime that is punishable by less than 1 year in prison. A felony is a crime where the punishment is over 1 year. Will mean you have to go over 1 year in prison. Okay, misdemeanors less than 1 year in prison. Felonies over 1 year. Examples of some crime: breach of peace, extortion. I know there's a list in the book. Breach of peace is usually a misdemeanor. Extortion could be a felony. Okay, arson, definitely a felony. Okay, depends on the degree. Classifications: misdemeanors are usually less serious offenses, less than 1 year in prison. Felonies more serious, probably have some rapes, murders, some kind of physicality to it. More serious offenses over 1 year in prison. Okay. Examples of crimes, like we talked about: breach of peace, trespass, extortion, arson, murder. I mean, breach of peace is usually a misdemeanor. Murder, definitely, it's going to be a felony. Okay. The essential elements of a crime: the criminal act itself. All right. The person who is alleged with the crime must perform the prohibited act. All right. That could be killing somebody, failure to pay taxes, whatever. All right. But they must have performed that prohibited act. All right. Thinking of committing a crime and taking no action is not a criminal act. Okay. Thinking of committing a crime without taking any action towards perpetrating that crime is not a criminal act. Okay. Just thinking about it, no. Criminal actor must perform some aspect of that crime. Okay. Criminal intent is the second element. All right, it's the subjective state of mind that a person has, if they really want to commit the crime or not. All right, there has to be some intention to commit a crime, or it has to be knowing that this is wrong. Okay, could be reckless, or with criminal negligence. All right, there has to be some form of criminal intent, and there's 4 subjective state of minds that a person can have that would be considered intent. As intentionally doing it, you murdered a person, you took a gun, you shot him, you intended to kill him, you knowingly did something that could result in someone getting hurt, you recklessly did something, you drove drunk. All right, you were reckless. All right, you got into a car, you got behind the wheel, and you got on the highway and you hurt somebody. You were reckless. That shows criminal intent, or you just may have been criminally negligent. Okay, it's the least amount. It's negligence, but there's some criminal aspect to it that shows that you had some intent of committing this crime. Okay, so criminal intent is 4. Intentionally, you did it. You know you're going to do it. You purposely did it. You went out and did it knowingly. You knew that your act could result in somebody getting hurt, or could result in somebody losing money or something. You're reckless, got in the car drunk, behind the wheel drunk, or you just did it with some form of criminal negligence. All right, there's specific intent, which is intentional, and general intent, which is knowingly reckless and with criminal intent, criminal negligence. All right, so it depends on the crime. All right, some crimes require you to have specific intent. Some just require you to have general intent. All right. Criminal procedure. All right, this is the process of initiating and maintaining a criminal action. All right, it starts with the arrest or indictment. All right, you could be arrested or you can be indicted. Our arrest is when the cops see you on the street doing something and they immediately arrest you. Indictment is when they go in front of the grand jury. The prosecutor puts evidence onto the grand jury, and the grand jury feels that there's enough evidence, therefore, to bring you in and subject you to the criminal process. All right. Another word for indictment is just an information. It means the same thing. Once you are arrested, you're brought in or indicted, and you're brought in, you'll have a right to an arraignment. All right. What the arraignment means is you go before a judge, and a bail will be set. All right. The judge will take the recommendation of the prosecutor, take the recommendation of the public defender or the private defense counsel, and they will set a reasonable bail. All right. So you may just be let out on your own recognizance. All right. You may be subject to $1 million bail. You may not. In certain cases, there may be no bail allowed. The person's too dangerous. The person's a flight risk. Something like that. Okay. So you're arrested or indicted, and then you're arraigned. You're brought before the judge, and the judge will say yes. Do $10,000 as a bond. You can be released, and just show up for your court dates, and everything's fine. Or you could be let out on your own recognizance, or the judge may say you're too dangerous, the risk is too high that you'll flee, so we're going to set no bail. That means you sit in jail until your trial until your trial date. All right, and then as the process goes on, most cases are resolved through some form of plea agreement, some form of agreement between prosecutor and defense counsel, saying, or we'll agree to this. You drop these charges, we'll agree to plead guilty to this charge, and my guy goes home. My girl goes home. Okay? The arrest warrant, you need to know if the person is being arrested on a warrant, that warrant has to be based upon probable cause. Okay? Probable cause meaning the substantial likelihood that a person either committed or is about to commit a crime. All right, you just can't throw out an arrest warrant. No, the arrest warrant has to be based on some form of probable cause. That is substantial likelihood that a person either committed or is about to commit a crime. You have probable cause. You can go before a magistrate or a judge and ask that magistrate or judge to issue an arrest warrant. If the judge or magistrate does not feel that probable cause exists, they will not issue that arrest warrant. No, you have to show probable cause. There are still warrantless arrests, but they still need to be based upon probable cause. Okay? Not all arrests have to be with a warrant. It could be some warrantless arrest. All right? The probable cause may be the cops show up and they see you fleeing the scene. All right? They may have probable cause now to believe that you may have done something. All right? While you're running. All right? They don't know what you did, but they have a right to arrest you. All right? Or they show up on the scene of the crime and they see you with a gun to somebody's head. All right, well, we don't need to go get a warrant now. We have probable cause to arrest you right there. Okay, so there are arrests with warrants, there are indictments, and there are warrantless arrests. All must be based on some form of this probable cause. Post-arrest. All right, now you're arrested. You're in the system. You get booked. All right, that's the recording of the arrest. It's where you take your pictures taken, your fingerprinted. You're asked certain questions that you must answer, your name, address, that kind of thing. Anything involving the case, though, you lawyer up, and the police cannot ask you any more questions on it. All right, your fingerprinted mug shots, all that stuff. That's recording the arrest. That's the booking process. Jay-Z got booked a couple times. We all know this gentleman here. Charlie Sheen, we know he's been arrested a few times, booked, that's his mugshot. And Lindsay Lohan, yes, she's been friend to the criminal courts many times. All right, so this is part of the booking. You get a mugshot, get fingerprinted, that kind of thing. Indictment and information. That's a formal charge as opposed to an arrest warrant. Evidence is submitted to the grand jury. And grand jury could be between 6 and 24 people. And they evaluate the evidence submitted by the government, by the prosecutor or the district attorney. And they will say, based on probable cause, again, guilt or not guilty. And if they don't believe that there's enough information to indict, they will not issue an indictment. If they feel that there is enough evidence to indict or arrest, they will issue an indictment. Okay? But everything that they do, everything that they evaluate, all the information they evaluate from the government, from the prosecutors, from the public district attorneys, they have to believe that there's enough there, that there's probable cause that this person did or is likely to commit this crime in order for them to issue an indictment. Arraignment. At the arraignment, also, the accused is informed of any charges. Up until that point, the accused may not know what they've been arrested for. At the arraignment, they will be informed of the charges. You've been arrested for a DUI. You've been arrested for breaking and entering. You've been arrested for whatever. All right. At that time, you'll also be asked to enter a plea of guilty or innocence. Always innocence. All right. Never enter a plea the first day. We don't know what evidence the prosecutors have. We don't know what evidence the state has. You're going to enter a plea of innocence first because you are innocent until proven guilty. All right. So you enter a plea of innocence. You can always change your plea at a later time. All right. Third form of plea is nolo contendere. That means that you're not saying that you're guilty, but the state has a lot of evidence, and it's just easier just to plea out. Okay. Nolo contendere means just that you don't admit guilt, but you agree to the penalty. And the reason people do this is because a plea of nolo contendere cannot be used as evidence of liability in a civil matter. Let's say you're driving drunk and you hit another car. The state has a back or blood alcohol level on you. They have some video of you drinking, swaying in the breeze out there. You don't want to admit guilt. You plead nolo contendere. You agree to the penalty aspect of it. But now anything cannot be used in the civil action because if there's a car accident involved, that person's going to sue you civilly. But they cannot use this guilty plea in that case. Okay. Plea bargain. Again, plea bargain, usually it's an agreement between the prosecutors, public defenders, prosecutors, district attorneys, and the public defenders and criminal defense attorneys. They come to some form of agreement wherein the defendant may admit to a lesser offense. This saves costs, avoids risk of trial, and with the overcrowding of the prisons that we have, plea bargains are the general rule. Okay? Alright. Next section, we will get into certain crimes. That's all we're going to do on part 1. When you review this, review along with the book. Again, we're going to have a quiz on Friday on this topic and last module's topic. I will be posting a second video, so please take a look at that later in the day. Thank you.